okay for everyone. I think we already have 78 people connected, so it's not bad at all. Je vais donc faire ma présentation en français, mais la suite se déroulera en anglais puisque la langue des différentes présentations de Eleanor Sharpston sera l'anglais, mais avec une possibilité pour les étudiantes et étudiants de poser des questions ou d'intervenir en français, vu l'excellente connaissance du français de Eleanor Sharpston. Donc, chères étudiantes, chers étudiants, chers et chers collègues, dear Eleanor, dans la foulée de la leçon inaugurale qui s'est déroulée hier soir et a porté sur Taking the Rule of Law Seriously, but what does that actually mean? C'est un véritable plaisir et un honneur de vous accueillir à nouveau virtuellement pour la suite des séances de cours de la chaire Francqui. Cela permettra d'approfondir plusieurs des questions qui ont été évoquées hier et de prendre la mesure de l'importance du principe de rule of law, particulièrement pour les juristes en formation qui suivent cette leçon. Étant donné que nous avons déjà eu l'occasion de vous présenter hier, je serai brève et je rappellerai, juste aux étudiantes et étudiants qui n'étaient éventuellement pas présents à la leçon d'hier, l'énorme chance de pouvoir bénéficier de l'enseignement d'une spécialiste du droit européen de votre calibre. Votre parcours professionnel vous a permis d'appréhender le droit européen avec des regards multiples et sous toutes ses facettes. En tant qu'académique à l'University College London d'abord et à l'Université de Cambridge ensuite, où vous avez enseigné le droit européen pendant des années, mais également et peut-être surtout en tant que praticienne comme barrister et ensuite à la Cour de justice comme avocate générale pendant 14 années, jusqu'à votre départ l'an dernier lié au Brexit, sur lequel je sais déjà que vous reviendrez. Je dois dire personnellement avoir régulièrement eu des coups de cœur, très sincèrement, pour certaines de vos conclusions, toujours extrêmement didactiques et bien souvent très innovantes. Je songe notamment à celle rendue dans l'affaire Ruiz Zambrano, où vous revisitez le champ d'application des droits fondamentaux, dans l'affaire Bartsch, autour du principe général de non-discrimination fondé sur l'âge et où vous revenez à sa conception aristotélicienne, ou encore bien évidemment à celle rendue dans l'affaire Bouniaoui à propos de l'interdiction du voile islamique dans l'emploi. Et je me réjouis que vous réserviez des shadow conclusions aux deux affaires pendantes sur la même thématique que vous avez annoncé rendre publique à la mi-mars. Avant de vous donner la parole pour aborder le sujet de cette leçon qui va porter sur The Rule of Law, Why It Matters, je voudrais vous signaler, vous réexpliquer donc que les étudiantes et étudiants qui suivent majoritairement la leçon d'aujourd'hui sont principalement des étudiants de master en droit du cours de droit public européen que j'enseigne et également pour bonne partie des étudiants de bachelier du cours de comparative law qui est enseigné par ma collègue Isabelle Rorive qui vous écoute également aujourd'hui. Et enfin, je voudrais adresser un petit mot justement aux étudiantes et étudiants pour véritablement insister sur la dimension pleinement interactive de ce cours. Je vois que plusieurs personnes ont déjà enclenché leur caméra, donc n'hésitez pas. Bien entendu, pendant la présentation d'Eleanor Sharpston, c'est mieux de couper vos micros, mais elle va à plusieurs reprises vous interpeller, vous demander votre avis, vous demander de commenter, et ce n'est pas une formule de style. C'est vraiment son intention d'échanger avec vous. Et donc, comme vous l'avez peut-être entendu, si vous ne répondez pas, elle se taira. Il n'y aura plus de cours. Donc, c'est une opportunité pour vous et je vous incite à la saisir en sachant que vous pouvez, à votre libre choix, intervenir soit en anglais, soit en français et que pour les séances suivantes, on essaiera de vous donner une liste des arrêts qui seront principalement commentés. C'était moins pertinent pour celle-ci, mais pour les semaines suivantes, il y aura des listes d'arrêts dont vous pourrez prendre connaissance à l'avance, ce qui permet évidemment d'interagir de manière encore plus fluide. Donc voilà, ces quelques mots dits, nous arrivons à presque 10h08 et donc, Eleanor, thank you for accepting to host this chair and you have the floor for this next lesson.
Thank you very much indeed. Ladies and gentlemen, good morning to you. I'm going to underline a little bit of the housekeeping that Professor Brabozia has just been through. I really want to stress to you that this is meant to be interactive. It's true that I'm an EU lawyer, but for years and years before that, I used to teach law in Cambridge. And I didn't just teach EU law. I taught legal method. I taught introduction to law for the new students. In other words, I was really engaged in trying to help people to understand what it meant to be a lawyer. And I was a law tutor also for my college. So that's, if you like, where I'm coming from. Not merely that I should sit here. Normally I would stand, but virtual presence, I'm sitting. Not merely that I will sit here and supply you with wisdom, which you will kindly write and respectfully write down. That's not really how I like to teach. I like to teach by trying to get a common understanding of where we are going and why we're headed in that direction. And so it really will be interactive. And if it's not interactive, then we will start meditating. Yeah. In other words, if you guys are silent, then I'm not going to fill the gap automatically. I also want to say, vous êtes évidemment absolument libre, et je souligne le mot absolument, absolument libre. Si vous voulez intervenir, mais vous préférez intervenir en français, faites-le en français. Je préfère largement que quelqu'un s'exprime à son aise en français, au lieu de dire, bon, mais elle est anglophone, je vais quand même être poli, je vais chercher les mots en anglais. Et à ce moment-là, vous êtes crispé, vous vous trompez de mots, vous avez le trac. Moi, vous avez peut-être un petit accent en anglais qui va me dérouter parce que je suis à moitié sourde. Alors, c'est quoi qu'elle est en train de me dire, n'est-ce pas? Donc, ne soyez pas timide, hein, intervenez en français si vous le préférez. Et si vous intervenez en français, c'est aussi fort possible, en fonction de la question, c'est aussi fort possible que je réponde en français. Je n'ai pas affiché que tout ce que je dis doit obligatoirement être dit en anglais. Et à ce moment-là, je vais vous demander de bien vouloir m'excuser s'il y a des petites erreurs qui viennent s'intercaler. Alors, soyez gentils et oubliez les erreurs. Hein? Okay, against that background, there's one further piece of housekeeping I should say, which is the following. Today, there would have been no point in saying to you, please read the following cases before you come to the course. I will get to Professor Brabozia a list of cases for the remaining courses of this sequence. And I will also, possibly not instantly, but I will also put together, if you like, retroactively, a proper list with case references for cases that I ended up referring to in the inaugural lecture yesterday. And I will trespass on Professor Brabozia's kind offices for that to be made available if people would like it, to those who were following yesterday. So if they want to follow up and they think, what is that case that she mentioned? She probably mispronounced it. She probably did. That way it is possible for people also if they want to take that further. Right, now then, the rule of law, l'état de droit. By the way, I'm not sure that one is an exact translation of the other, but let it pass. When I say to you rule of law, what do you think of? What do you include under the rule of law? And why do you think it belongs there? Over to you.
Vous pouvez utiliser la main pour indiquer que vous voulez prendre la parole. Et donc, de nouveau, l'idée, c'est vraiment que vous puissiez dire sans avoir peur, donc ce qui fait partie, ce qui entre dans cette notion de rule of law. Don't be shy. Alors, je vois Sarah Brandes, oui?
Oui, bonjour, je vais parler en français. Moi, ça me fait penser à la démocratie, l'état de droit. Principalement, c'est la première chose qui me vient en tête.
Et si vous pouvez éventuellement ajouter la raison pour laquelle c'était les deux aspects de la question, donc des éléments qui sont, selon vous, dans la notion, et puis pourquoi vous rattachez ça à rule of law, si vous avez un élément de réponse.
Parce que, enfin, pour moi, les deux notions sont liées et on n'a pas l'un sans l'autre.
Merci. Une autre intervention? Someone else? Oui, Kevin Oua?
Oui, bonjour. Moi, je dirais, je parlerai de la prééminence du droit sur éventuellement d'autres modes de décision ou de gouvernance, et aussi surtout la soumission des dirigeants au droit.
Et Raida Tormen, pardon pour la prononciation.
Si, Raida Tormen, je pense à un État qui est basé sur la loi positive.
Merci. Et alors, je vois encore Kadiatou Kardoun.
Oui, bonjour. Moi, je pense à l'indépendance de la justice, parce que sans l'indépendance de la justice, il n'y a pas vraiment d'état de droit.
Je vais demander à tout le monde, s'il vous plaît. Je suis à moitié sourde. Donc, si vous parlez très doucement, ça va être davantage difficile pour moi de saisir ce que vous avez dit. C'est super poli, mais de grâce, soyez moins poli et parlez plus fort. Merci. Si vous voulez recommencer, s'il vous plaît.
Oui. Donc, pour moi, l'indépendance de la justice est importante pour l'état de droit, puisque l'état de droit, c'est le droit qui est en avant, et l'indépendance de la justice permet que le droit soit respecté au mieux.
Merci beaucoup. Et j'ai encore Johan Mardi.
Oui, moi je crois que l'état de droit met en avant donc le principe de légalité et de garantie juridictionnelle. Et si je ne me trompe pas, c'est également que la position que la Cour de justice et que la Cour européenne des droits de l'homme adoptent également en matière de, par rapport à cette notion justement.
Merci beaucoup.
Merci à tout le monde. C'est très utile comme point de départ. Let's work on what you've given me, and let me give you an example. I'm going to invent a country called Barbaria. You will discover why it's called Barbaria in just a moment. The ruler of this country doesn't like anyone who has red hair. He has a complete phobia about redheads. Barbaria does have a parliament, which is democratically elected, and the way that laws are made is that either the government or indeed the ruler can put a draft law in front of Parliament, and Parliament will vote and decide whether or not to pass that law. Well, the ruler is getting more and more phobic about redheads. And so he brings a draft law before Parliament, which is a law which Parliament, in fact, they listen, they're convinced, and they adopt it unanimously. So the democratically elected representatives of the people adopt the law which has been put forward by the ruler, but it's adopted democratically, and then he duly signs the law, and it therefore the full constitutional process is finished, and the law becomes a law. It becomes an enforceable law of the land. What is this law? The law is a law that authorizes, indeed that mandates, the police to arrest all red-headed people. Just because they're red-headed. Nothing further. The police is in the street. They see somebody with red hair. Some time ago, that would have included me. And they are instructed they must arrest red-headed people. And the red-headed people will be taken away to detention. And I will tell you that after a little time, when their relatives have kind of forgotten about them, they will be eliminated. They will be killed. According to what you have given me so far, I think that what is happening is an application of the rule of law. We have the link with democracy because we have the law which has been made by the Parliament, who are the democratically elected representatives. All the procedures have been followed. In order to respect what Johan said about the garantie juridictionnelle, I should maybe add that if one of the redheads challenges their arrest, they of course have access to a court, but they're not going to get anywhere because the court is going to look at them and see that they have red hair, and the court will see that the law says red-headed people are to be arrested. And I'm not sure what the court could really do except to say, yep, that looks to me like an application of the law. So we have a state that is based on law. There is the law. Do we have the rule of law on the basis of the criteria that you've given me and on the basis of the law that exists in Bulgaria?
Emmanuel, ton micro.
Je donnais la parole à Bruno Mro-Wiki.
According to what was said, I think that what we are missing here are values. I think that the law should not be interpreted out of the values like fundamental rights, human rights. So the law should be interpreted according to the values of democracy and fundamental rights, not arbitrarily, and should, And I think that that principles such as legality and also the control executed by the courts should be also made within the interpretation of those values. So without those values, we cannot say about the rule of law. Therefore, we always say democracy, human rights, and rule of law. And I don't think that we can separate them if we are talking about the rule of law. So this is my opinion. Thank you.
Thank you very much.
Thank you, Bruno. I'm very glad that we have a lawyer in this group who is going to be following that line of reasoning. We are indeed badly missing values. We have the rule of law, right? In the sense that we have a legal system and we have laws, and the laws are being applied. It's just that the consequence is horrible, right? By the way, we also had that kind of situation in Germany in the 1930s when the National Socialist Party was in power. We refer historically to the Nuremberg laws, the laws which were the anti-Jewish laws which eventually ended up with the Shoah. We don't call them the Nuremberg guidelines or the Nuremberg draft ideas. We call them the Nuremberg laws because they were laws. The only trouble is what the law said. Not that it was a law. I mean, the problem was indeed it was a law. It was an enforceable law that was meant to be enforced and was enforced, and the courts would uphold because the law was the law. But you are absolutely right. The problem with the system that I've described is the missing element is values. And of course, the problem is we don't have the values in the system. All right. So the rule of law, if I can suggest a couple of phrases you might want to write down. The rule of law does not mean, quote, I am going to be treated according to the law. That's not enough. If we don't have a system of values built in somehow, I am going to be treated according to the law may lead straight to the concentration camp. What we want is a situation where we say the law is going to treat me fairly according to a system of values, and therefore I want to be treated according to the law. Just saying I want to be treated according to the law if the value system isn't part of the legal system is not going to be enough. By the way, small aside here, I have always been very interested reading the Psalms, and it's not an observation that's unique to me. It's one that was made by C.S. Lewis a long time ago, that many of the Psalms aren't in fact about asking for mercy at all. They're about asking for justice. The psalmist is sure that if he can just get the case in front of the judge, if he can just get somebody to listen to what's happened, then he will get justice. But that implies that you have inbuilt there a value system, which means that if you can get your case heard, then you will be treated fairly. So that really leads me on to saying that the reference point for rule of law is not, therefore, is there a law? That's inadequate. You saw it was inadequate in my example of Barbaria, right? The reference point is not, is there a law that's being applied to me? It's much more, is there a codified set of values which will have a positive impact on the way that we're treated? And is the law, whatever the law is, and whatever it's about, is that law against the background of that set of codified values? If you're reasonably happy with that as a place to be starting from for our thinking, I am obviously going to ask the question, well, all right, how are we going to set about developing an agreed set of values, and how, within a whole mass of rules, how are we going to decide what is a core element that's essential to the rule of law? So if it's not there, we don't have rule of law. And what is a side element which is all terribly interesting, but it's not actually a core element? Now, I'm going to do the sort of trick which we play in Cambridge and we play in Oxford. I'm sorry, that's where I was an academic for most of my career. And so I'm going to treat you just the way I would treat a nice group that I was talking with in Cambridge or Oxford. And I'm going to play a game with you. I'm going to tell you that we have a group of people and they'd like to have fun together playing a game. And they have a ball. It's a round ball, and they look at each other and they say, okay, we're going to play a game. What are going to be the rules of the game? Well, the first question may be, how are we allowed to play the ball? Are we going to play it using our hands and our feet, or are we just going to use our feet? Those of you who are really switched on at 10:30 in the morning will have worked out that we're looking at the difference between soccer and rugby. There's also the shape of the ball, which I didn't mention to you. All right. So our first decision is, what are we going to do with this ball? What are you allowed to do with the ball? Must you just kick it with your feet, or can you both kick it with your feet and actually put your hands on it? By the way, if you put your hands on it, can you do anything with the ball? I mean, can you throw the ball forward? If so, you're in American football. Or do you have to pass it backwards? Ah, that's rugby. And by the way, within soccer, there is one player who is allowed to touch the ball with his hands, of course, the goalkeeper. Everyone else is not allowed to touch the ball with their hands. And if they do, the hand or the arm, then it's a violation of the rules. And then, of course, there are lots more rules, all right? If you ever, one of the stranger things I did when I was a lot younger is I trained as a soccer referee. And when you're doing that, you learn all these rules about the size of the pitch and the distance between the flags and the distance between the lines that go on the pitch and so on, all right? And of course, when you are talking about the Bundesliga or something like that, or Premier Division in the UK, then you have many, many additional rules about sponsorship. You have all the different strips that people wear, and so on and so on. Right. I've just been describing football to you. What in there is a key rule and what isn't a key rule? You can, by the way, add more examples. I was just trying to give you enough stuff to play with. Within what I've been giving you as rules, what is key to saying, yep, this is right, this is soccer? And what may be there as an additional rule, but doesn't actually matter?
Can I intervene?
Yes.
Can you hear me?
Yes.
Okay, so basically, from what you just said, one of the essential rules that distinguishes football from rugby is that you cannot touch the ball if you play football, right? You cannot touch the ball with your hands, and that's, well, basic rule.
Je vois Rifou Latunji. Est-ce que do you want to intervene?
Yes, for me, one of the core rules is also only one person can touch in football, only one person can touch the ball with his hand, the guardian. Yes.
Et Sarah Albaladejo Vargas.
Oui, je mets pas ma caméra parce que j'ai une mauvaise connexion, mais for me, the rules of football would be those that every country playing football would agree on. So if the UK, like you mentioned, had some specific rules on sponsoring or stripes or whatever, then that's more specific. But if all the countries playing football have a specific small set of rules, then those are the core set of rules for football.
Thank you. Johan, mardi?
Oui, je pense également au nombre de joueurs par équipe, où dans le football, ils sont 11 et au rugby, je pense qu'ils sont 15.
Alors, je n'ai plus d'intervention sur le fil de discussion. Ah, Sibel Top, si.
Hello, can you hear me?
Yes.
So for me, it's something that no one mentioned, but the aim of the game, the two games are different. So what they aim to achieve and pursue are different. And that would be, I think, fundamental in defining what is what.
So, sorry, can I just ask for clarification? Do you mean the scoring system? Do you mean how we decide who wins and who loses? Or when you say the aim of the game, do you mean something different?
Yeah, I mean what the purpose of the game. And for me, the values would be comparable to the purpose of the game in the system. So for example, the legal system would be also there to support certain values, so to protect and uphold certain values that are, for me, the aim of the game, and the game being the legal framework.
Oui, mais lorsque vous me dites qu'il y a certaines valeurs qu'il faut soutenir, est-ce que le résultat, est-ce que la question de savoir comment on décide qui a gagné, est-ce que les valeurs ont un impact sur cela, ou est-ce que vous êtes en train plutôt de dire la façon dont on joue le jeu doit quand même refléter une certaine approche à la vie, et si on joue autrement, c'est pas correct?
Oui, c'est ça. En fait, c'est les deux, je pense. C'est que le système a un but en soi, et la façon d'arriver à ce but, les deux tendent à l'accomplissement de certaines valeurs. Le but plus la façon d'y arriver, je dirais.
Et je vois aussi Bruno Mrawicki. Votre son.
Okay, thank you. For me, what is important, I think, is the aim of the game, but the aim meaning who wins. I mean, what are the rules? If we follow the rules, what do we have to do to win the game? I mean, who scores more, or who gain more points? This is one thing. The second thing is, if you want to know what we play, often you...
All very helpful. All very helpful. Thank you. Thank you. Yeah, go on.
Alors, Maxime, vous vouliez réintervenir? Ou you want to intervene again? No, you have your hand is raised. That's the reason. I think everybody has said, everybody that wanted to say something.
Very good. All right, now let's take the various rules that you gave me, and let's imagine different contexts in which football is being played. One context, all right, is a game between two amateur clubs in the same country. Another context is boys playing football on the street in Brazil. I'm going to confess to you that why I take that example is that when I was 6, as a child, I went to live in Brazil for 4 years. And I saw the boys playing football in the street, and I really wanted to play with them. And that is why I learnt Portuguese as my first foreign language after English. Because if you are a small girl and you're a foreigner and you want to play with the boys, you'd better learn Portuguese. I will also tell you that my Portuguese, in consequence, although it is very fluent, is not the kind of Portuguese that you would use talking to the Supreme Court in Lisbon. It's very, very crude. It's more like, Gilberto, you son of a whore, pass me the ball, you stupid blind bastard, can't you see that I'm free? Right? And you don't use quite that Portuguese when you have a polite meeting between top-level lawyers. But that's why I'm putting this particular example in there, all right? Because my third context is an international game. We'll have, well, I mean, you pick your teams if you like. We have German. We have German. Let's keep it away from UK. We have Germany against Italy. All right. So it's an international. Now let's have a look at various rules that you've told me about, but also rules that I mentioned to you, and let's see what matters and what doesn't matter. I think that knowing who wins is going to be very important for the international game and probably for the amateur clubs, although not necessarily, because if it's a real friendly, they may not mind at the end who actually won, but they do want to mind about how you score. They have to agree what is a goal and what isn't a goal. Otherwise, it's not going to be friendly at all. It's going to be very rancorous. And actually, the boys playing in the street, let me tell you, they're really, really tight on whether something was a goal or not. All right. So everyone's going to care about who wins if we follow the rules, what is a goal, and the fact that the scoring system, you have to agree the scoring system. You also have to agree what the goal looks like. If you are in the international context, you have got a standard goal painted white with the netting in the right place. It all measures up. If you're a friendly between two amateur clubs, it's probably a standard goal, but you know, maybe it isn't quite standard.
Je pense qu'il y a un problème de connexion.
Oui, on peut peut-être attendre 2 minutes. Et puis, voilà.
Je vais appeler peut-être Eleanor. Pour les personnes connectées, on essaye d'inviter.
Voilà, je suis là. Coucou, je suis là. Non, mais it's one of the hazards you live with, right? At these times, is that your speaker may suddenly disappear. All right, I think you've probably heard me say that in most contexts, you need to know who's winning, and you need to know what counts as scoring a goal. You do not need to standardize in every context what the goal actually looks like. And you know this from watching people play football in the park, all right? If it's an international game, you expect to have the full-size goal. If it's playing in the park, you probably have 2 tracksuit tops that have been put down on the grass to show where the goal is. Similarly, if it's an international match, it will be played on an international size pitch. And all those rules about where the lines are and how the flags are and so on, they're all very relevant there, as are the rules about what colored clothes people are wearing and the fact that the goalkeeper wears a different colored shirt so you can see that he's allowed to use his hands. All that detail, which is important to the professional game, even important to a certain level to the amateur game, it's completely unimportant to the boys playing football in the street. You know, half of them don't have shoes, never mind having matching shirts. But of course, if they want to, you know, to make a show, one of the first things they're going to do is to try to get matching shirts. But that's a matter of team identity. It's not because you need matching shirts in order legally to be able to play football. Of course you don't. Now, I mean, I've deliberately taken that example, all of that example, because we can use that same analysis if we were to talk about an area of law. If we talk about the rules on evidence, all right, something which is highly relevant to the actual conduct of litigation. Within the rules on evidence, there are going to be some rules which really are important. Rules about how you test witnesses, whether you can test witnesses, whether you should know in advance of the trial what the essence is of what a particular witness is expected to say. That witness will be called in order to prove this point. It's all right. My dogs are probably going to come in just a minute. I just saw a cat, but don't worry, my dogs may have seen it too. And that will be entertaining. So rules of evidence, there were some rules in there about being allowed to test evidence. If I think across to English law, there are, as you maybe know, we put a lot of emphasis on oral evidence, because we think that when the judge and the jurors see a witness there in person, it's easier to decide whether the witness is lying than if you read what they think they might like to say. So we like to have oral evidence. We don't like to let people prove things with documents if you should be proving them orally. We also have a very strict rule against hearsay, that a witness can't tell to you what someone else says they think they saw, because it's too far away. You need to be able really to test. And we would say all of that is very essential. Fine. Now go and look at somebody else's rules on evidence. They're not going to be exactly the same rules. I guarantee, without turning this into a specialist seminar on the law of evidence in all the different member states, I absolutely promise you that we will not find exactly the same rules on evidence in all our countries. What we may find, what I hope we're going to find, is that in all our countries, we think that it is important to have certain standards for the evidence. We think it's important to let evidence be tested. We think it's important if we're talking about a criminal case, or for example, if we're talking about the terrorist context and somebody has been put on a blacklist because they're a suspected terrorist and they want to challenge that decision. We think it's important that people should know the case against them, because unless you know the case against you, how are you going to challenge it, right? Now, how you go about that in the different systems is going to be different. How you make the value system work with the technical rules of law will be different. And by the way, there will probably be some rules in there which, if you're a practitioner in that country, you know you have to keep. Otherwise, you're going to get into terrible trouble with. But actually, that rule is not essential to the rule of law. I'm going to give you my favorite example from the context of doing cases in front of the Supreme Court in the United Kingdom, the old House of Lords. The House of Lords used to have different rules from anyone else on how you actually presented documents for the House of Lords. So if you were presenting a petition, it was all very respectful, right? If you were presenting a petition to the House of Lords, instead of the document being a white paper document with a clip holding it together, or it was in a file, you needed to put in the petition as a document that was between two covers that were blue covers, and not just any blue. The rule said the cover had to be cornflower blue, so the same color as the flour, the cornflower. So you couldn't use a, God help you, you couldn't use a red cover, But even if you use the wrong colour blue, the appeals office at the House of Lords would phone up and say, this is incorrect. This is not according to the rules, right? Now, I am seeing from some of the smiles that I can see on the cameras, right? I can see that maybe you good guys agree with me that the rule that the documents must be inside a cover that is cornflower blue is maybe not a core rule. It's a rule you have to keep if you want to plead the case in front of the House of Lords. But truly, the future of civilized democratic society and the rule of law does not depend on whether that cover is cornflower blue, or indeed on whether it's blue. Now, I'm making the point here because I think it's very important to understand that many, many, many issues that in practice you think about and you make the argument, it is part of the rule of law that X. These are arguments about classification. They're arguments about whether a particular rule which has not been respected, whether you can say that rule wasn't respected and that was a violation of the rule of law. It worked to my detriment that the rule wasn't respected, and I wasn't given a fair trial because it wasn't respected. And that is about classification. It's about deciding whether the rule that we're looking at is a really serious rule about the type of evidence that you can bring, or it's a rule like the rule about the cornflower blue covers on the document. And one of the really important aspects of preparing a case, and one of the really important aspects for the judge in judging the case, is deciding where to classify the rule or rules at issue. Now, something that didn't get mentioned at all deliberately by me, but also didn't get mentioned by any of you about when we were talking about football, is whether we have a referee. And if we have a referee, what the relationship is between the players and the referee, and what the qualities are that we want in the referee. So I'm going to start outlining that. We will make a break at 11 o'clock, which will give you all the chance to recover from my teaching style and get brave, maybe just grab some coffee and get brave so that you can endure another hour of it. I'm going to start talking to you about the referee, and of course I'm going to start in the context of my football game because that's the teaching place to start. So of the different types of context in which we're playing football, the boys playing football in the street, well, there may be a referee, maybe, very probably not, or maybe there is one person on each team whom they agree that, okay, if there's a disagreement, we're going to turn to those two boys and say, what do you think? Do you think that was a really, really dangerous way of playing? So we should send that boy away. He shouldn't be allowed to play. What do you think? Was that a goal or not a goal? I mean, are we going to decide it by a mass, democratic vote? Everyone says it's my team. It was a goal. It was a goal, right? And then the other team said, no, it wasn't a goal. It wasn't a goal. Yeah. Or are you going to have the two captains of the two teams because you trust them to be, upright, decent guys, and even if it's against their team, they'll admit that it was a goal because the player wasn't offside, right? Or are you going to have a referee? Think about it. Usually, if you're talking the two amateur clubs, you're going to have a referee. If you're really unlucky, you might get somebody like me. So you'll get somebody who in principle knows what the rules are, but has very little experience actually in refereeing, who maybe is, getting a bit older and a bit slower, so they don't run fast enough, So maybe they're not in exactly the right place to see what's going on. They probably don't have linesmen to work with them. They certainly don't have, you know, this code. We're all used to seeing the referee doing this, saying that they want to have a look at the video. Yeah. Well, I mean, there's no way you're going to have the video replay, right? And so you're going to make up your mind. And by the way, you may be wrong. Important point, the referee may be wrong. The referee may not be willfully blind, and the referee may not be biased, but the referee may also be wrong. The referee is a human being. The referee may be wrong. It may be a marginal decision, and they may, in fact, have got it wrong. If it's a big international game, you will have, of course, have all the paraphernalia. You will have the linesman, who will be, you know, people who the referee can say, what did you see? Okay. Share our shared information. Right. In that case, that was indeed a foul. You have very clear marks. So you actually know there's a line, so you can see if the ball went over the line. You haven't got a line if you're playing football in the street. You vaguely know what the edges of the pitch are. So you're probably not too worried about whether the ball went over a non-existent invisible line. But of course, in an international, you're very concerned about that. And you have the backup, as I say, you have the video. And of course, you have all the press and all the commentators who will immediately after the game go and replay everything and show you whether the referee was right or wrong. So there's a lot more pressure on the referee. So maybe you need extra qualities in your referee. And of course, the referee is going to have more experience. Sure, I know. What about the relationship between the players and the referee? The players, by the way, are probably getting much more money than the referee is getting. If you're talking the big games, the big clubs, right? Now, does that mean they can argue with the referee? They say, excuse me, you know, I make 3 times what you make in a week. I make 3 times what you make in a year. You know, just little man, go away. No, of course not, because we can't run the game like that. Yeah. So we have certain standards, the certain respect codes between the players and the referee vis-a-vis the players. I make the point about money, by the way, because one of the phenomena you may want to think about is that in many countries where you have a professional judiciary, if you become a career judge, you get less money but more prestige than if you become a practitioner. Now, maybe that doesn't matter too much in France or in Belgium or in Italy. It may matter like hell in a developing country because the judge may be so poorly paid that they are very open to corruption. Not because they're wicked people, but because what they are getting in terms of money is barely enough to feed their family. And so, you know, there are issues within issue. If you want the judge upholding the rule of law by taking the laws and applying them correctly and fairly and independently and impartially, there may be certain additional parameters that you have to put in place. It may not be as simple as saying, okay, just as you have a referee in football, you have a judge, problem sorted, job done. It looks to me as though the natural place to make the little break before we go on. So I'm going to suggest to Professor Brebosia that this is a good moment for us to break for 10 minutes, if you agree.
This is perfect. Thank you so much for this first part. And we come back in 10 minutes, is it? And if you want to raise some questions through the chat box, we will be able to look at it during the break. So
that's a good idea, because that will also inform how we use the next part of this session. So see you all shortly.
Thank you.
Emmanuel, est-ce que vous pouvez me dire comment on regarde le chat pour voir ce qu'il y a dans le chat?
Oui, c'est au-dessus. Donc, il y a une barre avec une bulle comme dans les bandes dessinées avec des petites lignes.
Ah, show conversation.
Yeah, that's it.
Aha!
There are 2 questions that were already written regarding the referee, if you want.
Oui, il y a une question de Johanna.
Voilà,
Hein?
oui. De Yanja et Johanna. Une plus haut aussi.
Ok, attends, je montre là. Excellent question from Yanya. Yeah. Very, very good question. Excellent. I should leave that. Let me make a note to myself. Okay. Let me just check on my dogs.
Okay, important. Rudy and Boris.
You're all right, darling. You're okay there. Very good boys. Yes, good boys. I have they're both being as good as gold. Very good. They are.
Oh, sleepy.
Well, we went out much earlier, and because I took them for their walk, because they have a walk in the morning and a walk in the evening.
Excellent.
Sometimes they also have a walk in the middle of the day if I need to think. And it was a very lovely, it was a cold morning, but the sun was out and the smells were good. So they ran around and they smelt everything. And then they had their breakfast. And then, I mean, after that, you.
Okay, I think you could start if it's okay for
Very
you.
good. Yeah, I will restart. Let me just take a gulp of water. And let's restart. And let's restart. I'm delighted to have seen 2 points come through on the meeting chat. My thanks to Yanya and to Joanna, and I'm going to work that into what I'm saying. But I'm going to invite us to look just a little bit. First of all, at the background of the referee, and then what we think the rules are that should be governing how the referee should be looking at the law. And I'm going to emphasize this because we're going to need our referee, our judge, to be prepared, if necessary, to uphold the rule of law against the executive. It's very, very rare that the executive needs help upholding the rule of law against individuals. Usually the executive has got all the power it needs. It is much more usual that an individual needs help against the executive. Now, that probably also tells you something about my background as a lawyer, because when I was a barrister, I did lots of cases for the UK government, but I did also lots of cases pro bono. So I used to use the money that the government paid me in the government cases to buy my own time to do the pro bono cases against the government, which is something which is perfectly acceptable at the English bar. It might cause a few eyebrows to be raised in some other context, but at the English bar, they kind of know that there are people like that, and they say it's important that the bar is independent. They also sometimes say that bloody woman, but you know, they tend to say that rather quietly. It's not meant to be the official reaction to a barrister being independent. So let's talk a little bit, though, about what we want our judges to be like. If I were to ask you for a shopping list for things I should be writing down about the judges, what would you tell me?
Alors, la pause... Ah, voilà, donc Marcin Mrowicki.
So, when we are talking about the referee or the judge, I think that there are certain important issues that should be underlined. First of all, he should be impartial and independent, and there should be also some kind of guarantees that could enable him to be impartial and independent. For example, as we said about this respect code, so the judge or the referee should have some kind of immunity in the way that even if he makes some kind of wrong or not satisfying decisions, he should stay. He shouldn't be, I mean, in any way, the decision should be respected. So there should be some kind of mechanism guaranteeing him that that he's independent in this way, that no one will influence his decision, and also that his decision will be respected. So, yeah.
Thank you. There is also Rifu Latunji who wanted to add something.
Yes, I wanted to say some basic things. I want to say that the judges must be skilled. They must know well the rules of the game or the rules of the area they need to. Yeah.
Okay. Thank you. Anybody else wanting to add something? On the chat box, I've seen just from Anna Paula, they should be independent and aware that they may be wrong.
I think that's an excellent reminder that all judges would do well to put up in front of their desk. Just remember, you may be wrong. Because it is very easy doing the job of a judge or indeed of an advocate general to end up believing that you are cleverer than everyone else. And so therefore, you know, you must be right. So it's actually very important to have that reminder that you might be wrong. I think that's that is seriously important. I'm sorry, I'm trying to look simultaneous. Also in what's in the chats, because
there is also the independence of the body that appoints the judge.
Absolutely, and I think I'm making a note for myself je me conseille vivement la lecture des cours de Bourdieu au Collège de France. I'm making a note to myself that I should have got them out before I did this, but I certainly might go and have another look at them. Okay, you have come up with some things which are indeed on my very much, but my list has also got some other things on. cases that are politically sensitive or where the press is howling for their blood. There may be some limits to immunity. For example, if they are negligent in doing things, they just don't bother to read the papers and they get it wrong. You know, do you really want them to be immune? But when you say, if you say you don't want them to be immune, then you might be saying, well, you might want it to be possible for them to be called in by a senior judge and then, you know, you must read the papers, but that they shouldn't lose their job. So, you know, there's levels of immunity and levels of reaction. My list, obviously, like yours, had things like independence, intelligence. It'd be nice if they can think, okay. Impartiality. I wrote down with 2 question marks by it the word speed, because if you say to the judge, you must go very, very fast through your caseload, they're going to make more mistakes because they won't have time to read and think about what they're doing. On the other hand, we all also know the quotation that justice delayed is justice denied. So if they get through 2 cases a year and do them perfectly, that's not going to help the rule of law very much either. I've got other things down on my list. The appointment procedure, of course, is important, how that works. What kind of tenure they have. Are they renewable mandates? That makes you more open to outside influence. Is it a fixed term, a non-renewable? Are you appointed for life, like to the US Supreme Court? And then there are all the conditions around it. Prestige, remuneration. Thank you, Jana. It is an important question. If you get both prestige and remuneration, that makes it, I think, even more important that you should respond to what society is investing in you by giving you the money and the prestige, by being absolutely independent, impartial, and not having other activities that may encroach on you doing your job as a judge. There is a reciprocity there. There is also, I've written down a word which is noticeable by its absence at the court where I've just spent 14.5 years, and the word is training. Nobody trains a member of the Court of Justice of the European Union in how to do their job there, whether the job is to be a judge or to be an advocate general. There is no on-job training. If you were talking about a national legal system, you would almost certainly say that you thought that the judges should get training. People should maybe get training before they become judges, and you would want them to go on being trained to make sure that they had that. There was the comment about whether the judge must be skilled, must know the rules. Here we have different conventions. There is one convention, it depends which tradition you come from. There is the tradition that the judge is censé connaître le droit. You know, that the judge knows the court knows the law. In the common law tradition from which I come, there is a slightly different tradition which says that it is the duty of the barrister appearing before the judge, and it's a very heavy duty sometimes, to draw to the attention of the court absolutely everything that is relevant to the judge making his decision. So it's not that you assume the judge doesn't know the law, but that there is a complementary and important obligation on the barrister to make sure that you do put before the judge everything, including decisions. You probably know we have a very tight system of precedent, including decisions which are adverse to your position. If you know that there's a ruling that is adverse and that might help your opponent, you are under a duty to disclose that to the court and to disclose it to your opponent. So actually, in advance of the case, you say, when I was researching this, I came across this case, which I'm sure you're going to find helpful. Big smile. Of course, I'm going to say to the court it should be distinguished. Big smile. But you can't hide the authorities. You know, in this tradition, this is also very much part of the rule of law, that you should be making sure that the court does consistently apply the law, and therefore that the court knows what previous decisions have been. So, you know, all of those elements are going to come in. We haven't yet gone on to how the judge should actually behave in terms of rules that govern how the court's cases run. But before we go there, I'm going to ask the question, so how do you best guarantee getting a good judge? Because we do things differently, all right? In some countries, you have a separate career judiciary. You know this well from France, from Belgium. People go into the judicial stream rather than becoming advocates. If you have a clever young judge operating in a collegiate court, but he's young and inexperienced, you may want to have much tighter mandatory rules about what the judge should do in what circumstances. If, on the other hand, you do things the way that the common law system does in the UK or in Ireland, what you do is you take somebody who is much older, who is a practitioner, who's got lots of experience. They've been out on the street for 15 years. They know most of the dirty tricks because they probably did them themselves. And they've got lots and lots of mileage on the clock. They have got lots of time as a practicing lawyer behind them. And you make them a judge, and then you write your rules so that the judge has a lot of discretion. Now, you can make out an argument for either system, and you can say, my system works. What may not be such a great idea is if you mix and match. So if you have a very young judge, but lots of discretion, or you have a very senior judge, but you try and put him in a very tight box with the rules, that really may not work. And then you ask the question, here's another favorite area of disagreement. And again, it's a rule of law question, because depending which side of this divide you think the other breaks the rule of law. When you list a case before a court, can you change the composition of the court in order to adjust the court to what the case is about? Now, this is really different in the different systems. In the common law system, it is perfectly usual to try to list a case before a judge who has some expertise in that area. It's usual to do it because it's time efficient. You don't have to start at the beginning with the judge. The judge already knows a lot of the authorities. He probably sat in some of the earlier cases. And, you know, it's efficient. Well, it's efficient, but the counterside of it being efficient is that that judge has his particular views on how that area of the law is meant to work. If you're in front of a judge who's given 3 reasoned judgments, which are the judgments that your opponent is going to be relying on, and you find you've got the same damn judge, you swear a bit, you know, you think this is not great. And you wonder whether there's any reason where you could actually suggest it should be relisted. I mean, you know, very differentially. If you're not in that tradition, you have the different tradition, the French tradition of the juge légal, the German tradition of the gesetzliche Richter, you know. The composition of the court is absolutely sacrosanct. At the moment when the case is allocated to that formation of judgment, you look at the list, you write down which judges should be sitting, and that's it. I mean, somebody may not be able to sit because they're sick, but you certainly cannot fiddle with the way that the case, the composition of the court is, in order to get something different. And then, of course, you've got systems which are you know, kind of a bit between the systems. For example, the Strasbourg system, you will have the judge from the country in question who is part of the composition of the court. In the Court of Justice of the European Union, you won't necessarily have that. So you can have, for example, a case from Germany where it would be really useful if there were a member of the court sitting who knew about German constitutional law, but your German judge, Thomas von Danwitz, is not part of the composition. And if it's like that, it's like that. You know, there are different ways of approaching this. And by the way, whichever tradition you're in, you have a tendency to think that the other way of doing it may not really respect the rule of law. So the rule of law is a little bit also in the eye of the beholder. I'm going to push this a bit further, and I'm going, because it's to do with the role of the judge and what the judge can do. Actually, what the judge can do is different under different traditions. Not only the amount of scope that is given to the court to override or to nuance the law, the interventionist judge, but literally what you can do. The most striking example that comes to my mind immediately is in relation to a statute which violates fundamental rights. So an act of parliament where the argument is this act of parliament in fact violates fundamental rights. In the civilian example, it violates the Constitution. In the UK example, this violates the Human Rights Act. If you are in the UK context and the rules of the Human Rights Act, we have parliamentary sovereignty, which is in there as a kind of sacred cow. What that means in practice is that if what is challenged is an item of secondary legislation, it's a statutory instrument, then all right, if the judge decides that that statutory instrument is contrary to the Human Rights Act, which imported the ECHR into English law, the judge can strike down the statutory instrument. If it's not a statutory instrument, but an act of parliament, you have a problem. The court cannot strike down an act of parliament. All that the court can do, if the judge is completely convinced by the argument that this act of parliament in this respect violates a fundamental right under the ECHR, all that the judge can do is to issue a declaration of incompatibility, which is a nice piece of paper that says, yes, in my view, this provision of this law violates Article X of the ECHR. Signed, judge. Now, it's not the same as striking it down. Compare and contrast a constitutional court, which of course has the power to strike down a statute if it's unconstitutional, or to launch the mechanism for the statute to be revoked. Depends. And against this background, think a little bit about EU law, if you will. Think about the judgment in Siementhal. This very small judge, somewhere in a little court, somewhere in the back end of Italy, who is wondering what he should do because he has an EU law measure and he has an Italian statute. And actually in Italy, it is the Corte Costituzionale that has the power, the exclusive power to strike down a statute. And he's just a little judge. What should I do? Help. And the Court of Justice says to him, be a man. Under EU law, you can put aside that rule because it is violating rights guaranteed by EU law. And that's your job. You're in EU court. There was, from memory, about 2 years worth of discussion, some of it very frantic, in the press in Italy in the aftermath of Siementhal. But because nobody in the UK, or very few people in the UK, read Italian, the decision of the Court of Justice in the first Factor 10 case, that was the one about interim relief and setting aside a statute to protect by interim measures a right claimed under EU law. That is why the decision in Factortame 1 was such a terrible shock. The idea that you could conceivably do something which put aside a measure that had been decided by Parliament was outrageous. And even though deliberately the government had put in place the fishing measures, the removal of licenses from EU ships and the creation of a new fishing register, that had been done by primary legislation, by statute, precisely in order to try to keep it safe from interference by the courts. So that was a small illustration about how far what happens with the judiciary, with your structure, your arrangements, is going to impact on their supervision of the rule of law. And of course, you'll then have the rules as to what the judge should actually do in court. The obvious illustration is the rule on audi alteram partem, that you have to hear both sides of the argument. And if the judge hasn't heard both sides of the argument, well, so I hope there's an appeal, right? But there are also elements in there, everything which is to do with the rules of the defence, which we probably need to explore a bit later. I'm going to move across from there onto making some comments about substantive law and substantive law adjusting to places where we think that an adjustment is necessary. And I'm going to go on from that to some of the obvious sources for rule of law values, because we're going to end up needing stuff codified. If I begin, though, with statements about law, a lot of law is very fluid, and law responds to society. And you create a legal system, and then you realize that it's not actually working too well. I'm going to take a couple of very uncontroversial historical examples from the UK. They are very, very historical, so deliberately uncontroversial. A long, long time ago, the UK system operated on the basis of there being various writs that you could issue. And if you could issue the writ, you could get before the King's Court and you could have your case heard. And if the writ didn't exist, then you might have something that needed sorting out, but you couldn't actually get it out. And one of the obvious problems was if you had a debt between private parties, because there wasn't at that stage a writ that could be issued to bring that matter before the court. And then a solution was invented. And the solution that was invented is a bit comic, but it works. I mean, later, of course, they put the system right. But the solution that was invented was to invent the idea that you owed money to the Crown. Remember that the courts belong to the Crown. So owing money to the Crown, the King's courts are going to want to enforce that. So you had a debt against the Crown. But you couldn't pay that imaginary debt because you were owed money by your neighbour. And a writ was literally invented called the writ of quo minus. You went to the court and you said, I am unable to pay the king because he owes me money. And the debt to the king was imaginary, but that enabled the court to look at the claim between you and your neighbour and see whether, in fact, he owed you money and you should pay you. It's a very old historical example. Another, perhaps more recent and easier example to give you is the example any of you who've happened to look at English law, you know that we have law and then we have equity. We have equity because equity intervenes precisely where the pure legal rules seem to leave a hole. So you might have a situation where legally somebody, the classic example for perhaps from land law would be a situation where you had two people who had together contributed to buying a house, but the title to the house, the property, is in the name of only one of them. And, you know, they're two friends. They're not man and wife, you know, but they've both put money in. And then the friendship sours, and one says, get out of the house. The one who has the right to the house says, get out of the house. And the other person says, but I put up half the price of the house. I paid for it. Well, you don't have any legal title there. No says equity, but you have an equitable right because you put in half the money. And so equity will intervene to sort that out. So, I mean, law is, by the way, what we agree it should be, including some really, really strange things. If you go back into English legal history and you say, what is the basis for land tenure? Land tenure, by the way, is always weird in all our systems. You get some amazing arrangements. And there was a stage when you had an arrangement in English land law where you held land in return for saying masses for the soul of the person who gave you the land. And the type of tenure is called Francqui, and it was only abolished in the early 20th century. It took a long time for that one to go. So you have all the laws that are written down, but then there are other bits of law that get in there. They get in there from our constitutional traditions. They find their way in, not because they're written down, but because as the law develops, we begin collectively to accept that those aspects should be in there. I wonder if any of you would like to think, to guess, to offer ideas of what some of those elements may be.
Je regarde s'il y a des personnes qui souhaitent prendre la parole.
One of the answers, by the way, that I'm looking for has already been given to me, because one of the earlier interveners spoke about equality, which I could reclassify as a principle of non-discrimination, that if you have identical situations, they should be treated in the same way, and different situations should be treated differently, unless there is some objective reason for doing something else. But you should not arbitrarily have two situations which are effectively the same situation and treat them in different ways. And I mean, that is a fundamental principle which you find in constitutional traditions, you find making its way through into EU law and being reiterated in the case law of the court. But actually, for a long, long time, you don't find the principle of non-discrimination actually written down. Est-ce qu'il y a d'autres idées?
Anyone?
Quand même, hein, vous les connaissez. Vous êtes au courant, par exemple, du principe de la proportionnalité, hein, n'est-ce pas, les amis? I mean, proportionality, you find echoes of that in legislation, you find echoes of it in the treaty, but you find this as a general principle of EU law. And you find it there because a decent, self-respecting legal system has got it. Another example of a principle that got invented because it had to be invented was the principle that there is legal professional privilege, that there is protection for communications between a lawyer and their client, because the justice system works better if there is that protection. But when the AM&S case was heard, it was news. And this came through at a time when I was a stagiaire, in fact, working in the commission for that very, very fine and very great Irish competition lawyer, John Temple Lang. And I well remember that the day before the hearing in AM&S, Mr. Temple Lang was still trying to get instructions from the commission as to whether his instructions were to accept that there was a principle of legal professional privilege in community law, and then to argue about what the boundaries of it were, or whether he was meant not to accept that there was such a principle.
I see someone wishing to intervene. Giangia Cimenti.
Thank you. Can you hear me?
Yes.
Maybe I can add, these are not necessarily human rights related, but they could be. In the EU law, like the general principles of the primacy of the EU law and the direct effect of the EU law, can we say that these are some of the principles that were, let's say, not necessarily invented, but found later on? So the EU law found these principles not from the beginning, but from the workings of the court and from the workings of the judge. Could that be an example? Thank you.
Well, it's certainly an example that has repercussions, that has consequences, because if we take Van Gent en Loos, and I hope Flemish speakers among you will feel that that was a halfway acceptable way of pronouncing Van Gent. If we take Van Gent en Loos, we have the question there of what rights EU law confers and who can enforce them. Was the standstill provision on not increasing customs duty something that merely bound the member states between themselves, so that, you know, if there was a breach, the Commission could bring infringement proceedings, but that was it? Or did the customs agent, Van Gent, have the right to rely on that provision in order to say, no, you cannot charge the increased rate of duty on urea formaldehyde? Sorry, you have no right to collect it. And the rule of law, it's actually a very helpful intervention, thank you, because what is the rule of law really depends partly on the values we all think are there, but partly this is something that is evolving. Before Van Gent en Loos, before somebody had the courage to bring Van Gent en Loos, it was not sure what kind of a legal beast the EEC treaty was. Was it just a treaty between member states? Was it just another international treaty? Or was it something which conferred individual rights in certain circumstances on those who later became known as citizens of the Union? Once you say there is an individual right, then you start talking about, if we have rule of law, how does that right get enforced? Foreshadowing something that I will be talking about later in a different session. Let's think about the situation where you have sanctions that are applied against regimes that you feel are bad regimes. In the old days, if you didn't like, for example, Rhodesia and apartheid, or South Africa and apartheid, what happened was that the international community imposed economic sanctions on that country. Problem, the economic sanctions tend to hit the wrong people. They don't tend to hit the people who are running the country half as badly as they hit the poor people out in the townships. So if what you're trying to do is to punish the country for having a wicked regime, it's not a really great way of going about it as the international community, because you're hurting the wrong people. So then you move across to the idea of smart sanctions. And you say, well, instead of doing that, we will take specific measures against people who are involved in terrorism, people who are involved in dictatorial regimes, who often have funds nicely, conveniently hidden somewhere, for example, within the EU. We will take smart sanctions and we will take restrictive measures, we will freeze funds, we'll do all of that. Now, what you have done is to move across from a situation where you had a whole country as the target to a situation where you have an individual as a target. Oh, but wait. If you have an individual as a target and you believe in the rule of law, maybe that individual should have the right to challenge the measure that has been taken against him, which produces an adverse impact on him. So as you change your surrounding legal arrangements, you also change where your triggers are for the rule of law and whether a trigger is in fact activated. I'm going to give you another little example of whether I'm going to narrate a situation briefly, which I'm going to deal with in a later case, in a later session. Let's imagine we're looking at the common agricultural policy and we're looking at a market. We're looking at the market for growing tomatoes. There are too many tomatoes. There is a glut of tomatoes. And that does bad things in terms of the support mechanisms. And so what we do is we have a first go at this and we say, why don't we pay some of these farmers not to grow tomatoes for 3 years? And a number of farmers enter into undertakings not to market, and we pay them money. But there are still too many tomatoes. So then we introduce a new regime. We say, okay, you can sell tomatoes up to a particular tonnage. That's okay. If you try marketing more tomatoes than that, there is a financial sanction which you won't like. And then you say, all right, how do I know what my tonnage is? Oh, that's all right. There's a reference here. It's the tonnage of tomatoes you were producing in the reference year, less 2%. Here's the problem. The reference year that is picked is a reference year during which a number of tomato growers were not in the market because they'd signed non-marketing undertakings. They'd agreed not to be there, so they weren't there, so they have no tonnage in the reference year. So what this means in practice is that when at the end of their period of time they're not marketing, when they want to come back into the market, they can't get back in because they have zero quotas. They're not really very happy about that. So they go to court. Now, you are all from different traditions, I'm sure. How do you react to the set of facts that I've just given you? Do you say, well, you know, it's their bad luck. It's the right of the administration to run the market. So, you know, bad luck. Or do you say, wait a minute, I'm not too happy with that set of facts. It sounds to me as though it's not really in accordance with the rule of law, that these people should have left the market temporarily and then find they can't get back in. Out of curiosity, how do you guys react to that?
Some reactions? I'm looking at hands raised.
we can do this very simply. If people would raise their hand, if you like to call it twice, all right? Raise your hand if you think this is all right. See what it looks like. Raise your hand if you think this is not all right. See what it looks like. Okay, so we just see. If we were in a class, I'd say put your hands up. You know, which do you think? Is this okay or is it not okay? Those who think that it's bad luck but it's okay, would you like just to put your hands up? Right? If you take your hands down, and people who think that it's not okay, all right, who thinks it's not okay? Aha. I see a fair number of hands going up when you think it's not okay. I'm happy to tell you, and it's a case I'll be talking about properly later, that the court also thought this was not okay. It wasn't the market in tomatoes, it was a different market. The court also thought it was not okay. What was interesting was how everyone got to that conclusion. Because you see, we all have different things in our national traditions as to how we analyze. So for somebody who comes from the French tradition, it might be seen through the spectacles of confiance légitime. When you left the market with your undertaking, you had nevertheless a confiance légitime that you'd be let back in. If you are a German lawyer, you might express the same basic idea under the guise of Vertrauensverschutz. To me, as a common law trained lawyer, I would go straight to equity and I would say estoppel. The administration is estopped from behaving in that way when it has encouraged you to go and leave the market. It can't just turn around and shut the door on you. This is outrageous. Of course it can't do that, right? The case was decided on the basis of legitimate expectations under EU law. And the conclusion was that those who had left the market did not have a legitimate expectation that life would just stand still, but they did have a legitimate expectation that they would actually be let back in. And so that was the conclusion. I'm going to give you a very quick, in the last 5 minutes of this session, I'm going just to put a little marker or two down for things that we will be looking at and want to be looking at later. So we have seen that we get, as we start thinking about law, we think there should be values in there. And we insert the values into our system. How we insert the values depends. We may write them in a statute. They may be there in a constitutional document, in a Grundgesetz. One of the reasons why the Grundgesetz in Germany is as strong as it is and the Bundesverfassungsgericht is as active as it is precisely because of what happened in Germany in the 1930s. They wanted to make sure never again that they would entrench fundamental rights, hence the name Grundgesetz, basic law, right? And constitutional guarantees are equally at that level. Then we have all our international documents that start to pull together substantive rights, procedural rights. So you get the International Declaration, Universal Declaration of Human Rights. You get, obviously, within Europe, you get the European Convention of Human Rights. By the way, you can also take this way back, because at the moment when you get the French Revolution, you get the Déclaration des droits de l'homme et du citoyen. Being a citoyen is very important as compared to being a subject. Subjects, you just kick them around, they're the king's subjects. And you have to really fight and work before subjects get rights. You do get it gradually. But, you know, citoyen, it is all part of the thinking. We're not subjects, we are citoyens. Citoyens that are catalogues of rights. How much they're respected, that's a different issue, but at least we think that there should be rights. And some of the rights are substantive rights, some are very important procedural rights, like the right to a fair trial, Article 47 of the Charter, the Article 6 ECHR. And then you try and link across between your individual instruments. So, for example, as I'm sure many of you know, the Charter expressly cross-refers to the ECHR, and where you have rights in the Charter which reflect rights that are there in the ECHR, then you are to have regard also to the interpretation of the ECHR rights as handed down by the Strasbourg Court. There's an express passerelle there for the analysis. But then you ask the question, it's a bit the Animal Farm question, for those of you who know your George Orwell. Animal Farm, are all animals equal to each other, or are some animals more equal than others? Are some rights more important than others? Even though you have a document that protects lots and lots and lots of rights, are some of the rights really, as it were, at the top of a hierarchy? Well, one of the ways of checking that is to see what happens if people are allowed to derogate from the main convention. There is an express provision in the ECHR that deals with this, Article 15. Article 15 ECHR deals with derogation in times of emergency. And it says, Article 15.1, in time of war or other public emergency threatening the life of the nation, any high contracting party may take measures derogating from its obligations under this convention to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with its other obligations under international law. So the first subparagraph already makes it very clear that the right to derogate is a terribly small right. It's a right to the extent strictly required, and you must still respect your other obligations under international law. But then in Article 15, Para 2, we get a very, very, very clear signal. There are some rights that are so important that you may not derogate from them, even if you've got your state of emergency. You may not derogate. I quote, "No derogation from Article 2, except in respect of deaths resulting from lawful acts of war, or from Articles 3, 4, Para 1, and 7 shall be made under this provision." And if you go and look up to see what those are, all right, Article 2 is the right to life. All right, if you have a war, people may get killed, but that is deaths resulting from lawful acts of war. A genocide is not a lawful act of war, and if people die in a genocide, that is not a permitted derogation under the convention. You may not derogate from the Article 2 right to life. You may not derogate from Article 3, which is the prohibition on torture and degrading treatment. You may not derogate from Article 4, Para 1, the prohibition on slavery or servitude, and you may not derogate from Article 7, no punishment without law. In other words, there are some substantive rights which the rule of law tells us are so important that even in time of emergency, those rights are sacrosanct. They may not be touched. And I'm going to finish with just floating a little idea to you, because I've been spending time writing the shadow opinion in the Wales cases. So this is something I have very much on my mind at the moment. You have very often situations where there are competing rights. Where does my right end and where does your right begin? And does the rule of law imply that where you have competing rights, however you strike the balance, you may not actually strike it so that one right effectively disappears? Question mark. I'm going to stop there and thank you for your patience in listening and tell you that I look forward to meeting you again, albeit only virtually, next week. Emmanuel, back to you.
Thank you so much, Eleanor, and see you on next Monday at 4. I hope this question will inspire reflections for students. I'm sure it will. And thank you so much for this fascinating lesson today. So, bye-bye.